What's up, everybody? Welcome back into another episode of The Lawyer You Know. We've got a day off court today because apparently it's too hot over there in Boston, but we still have some conversations about this case, specifically the defense's case. We're over halfway through, so we're bringing Mark Bederow back on to talk about how the defense is doing, break down each of these witnesses, and some of the decisions the judge has already made and some of the decisions before the judge as we continue getting closer to the end of this trial. What's up, Mark?
How are you? Good to see you again.
You're back. You're back. I'm good. I'm great. It's hot here.
Yeah.
It's hotter than Boston.
Hot in Boston. Yeah, you know that.
Yeah. So we have the defense case. We talked a lot about it the last time we hung out, and we kind of tried to talk about what we thought they would do, what we would do, who we would call, who we wouldn't call, some of the reasons why. And now we're 6 or 7 witnesses in. And I wanted to kind of get your assessment as to how things are going for the defense. If you're sitting over there at that table, are you thinking, how are you adjusting? How are you adapting? Because in every trial, especially on the defense side, you don't always call any witnesses, right? Sometimes you call a lot. Sometimes you call a couple. Sometimes you call one. Sometimes you just call your client. Many times we don't call our client. And as the trial goes, you make these decisions and you have a lineup. I might call these 10 witnesses, and then you really decide who you're going to call as the trial is going on, and sometimes even as the defense case is going on. So as an overview of just kind of how the defense witnesses have gone, I think it's important to begin with where they started with DeSogra, the data guy, I guess, but as he was on the stand, he didn't do a lot of the downloads or explanations himself. He was kind of checking Shannon Burgess's work and maybe a little Dr. Welcher's work. What was your thought when they started with him, and how do you think he went?
I think he was an interesting start. I mean, I thought they would have followed him up with the the ARCA experts, only because it's getting into that kind of material. So they didn't do it that way, obviously. So is it a little disjointed, bouncing from him to dog bites to plow drivers and things like that? Maybe a little bit, but I think he was effective in the sense that Burgess already was kind of a compromised witness, kind of a problematic witness for the prosecution, and having your own expert say that he kind of screwed up his calculations, it can't hurt. So, I think it was certainly helpful in that regard. He didn't do his own work. He's just there to check Burgess's work. And I also think the other value he might give to the jury is he was very professional. He was very likable, very sincere. And I think he was a nice, a nice alternative to what the jury had just seen with Dr. Welcher, who, amongst everything, wasn't likable.
Yeah, I think in hindsight, now that we've seen a few more witnesses, he started out a very different demeanor and type of witness on direct and cross. And the defense is showing the dichotomy of, here's who we're calling. Here's who's part of our team, right? When we hear Buchanan and Proctor and all these people on their side that were very difficult, Welcher, like you said, Burgess with his credibility issues. Frankly, his demeanor was one of the better demeanors for the Commonwealth witnesses, frankly, with some of the most difficult cross-examination questions coming his way. But you're right. DeSogra really started it off with, we're going to see a difference in these witnesses. Now, I agree with you. I thought maybe not the biggest home run of a witness to start. And obviously you would think ARCA would come next, but after listening to him, I kind of think separating him from ARCA may have been a good call for the defense, because he didn't do a lot of his own work. He was just kind of checking work, and you're separating ARCA where ARCA did all of their own work. They got information from a different agency that is not state police and whatever we're going to call them, right? They got information from them. They did their own testing. Their data is their own. They didn't need DeSogra's testing to do their work. And I think that separating them is not going to make the jury confused, as if the Burgess-Welcher situation, they had to be intertwined. I think the defense is saying, no, ARCA's its own thing. DeSogra, if you didn't like him, ARCA's completely separate. If you did like DeSogra, then you're going to like ARCA too. So I do think there was maybe some method to that. I expected the same thing as you, that we were going to start with ARCA right from the jump.
So, yeah, look, again, in a perfect world, thematically, I would have thought it would have led into the ARCA witnesses. And I think presumably they'll hold up, that they'll establish in their opinion that it's not consistent between a pedestrian strike and a car accident. And I then would have liked to have seen, knowing what we know now, after ARCA, if they had put up Barrows after the experts had already established this taillight is not shattered, it doesn't make sense. And then here comes an active duty police officer as a defense witness, former prosecution witness, basically ran to the defense in between trials and then says, absolutely not, that taillight was not shattered. I would have thought that would have been an incredibly powerful, logical, thematic narrative to go from A to B to C, and then lead into kind of whatever witnesses they have, if any, related from the house or Proctor, that sort of thing, and then kind of then go to the plow driver, who I think would be a perfect logical following to any of the witnesses from the house or Higgins, those types, because then you have Laughlin, who he frankly had some of the best demeanor I've ever seen in any civilian witness ever, in terms of direct cross and what he was being subjected to. And he just very nonchalantly and apparently honestly, as far as I could tell, and I think most sane people would agree, said what he saw, and he was adamant about not seeing a body and then later seeing a car consistent with the Alberts and I think even Higgins. I think that would have been really a nice way to do it. But so they're a little all over the place, substance wise. It's an interesting way to do it.
Yeah, I looking back and kind of seeing how the witness has been presented, I think I may have, and you never know. And Laughlin and Barrows both came off significantly better in trial 2 than trial 1 from my perspective. And as lawyers, we think about that. How are they going to come off? Do we want? It almost feels like they were hiding Lucky a little bit, putting him in the middle just in case it didn't go well. Sometimes we think about stuff like that, but knowing how they came out, I love that idea. I kind of love the idea of starting with Lucky, then getting into, like you said, this did not happen in a car accident with DeSogra and ARCA. Then you can go into, right after that, you can go into Russell, who says, yes, this was not from a car accident, but you know what? I think it was from a dog bite. And I mean, that would have been a really nice lineup of this was not a car accident. This was probably a dog bite. We'll get into each witness individually because there's a lot I want to talk about with each witness, especially because I think we probably have some disagreements on some of them, and maybe even with kind of the topic I want to talk to with, what is his name, Diamantis or something, Proctor's friend. So Proctor's friend on the group chat, 9 people, they call him, they authenticate the group chat. Judge Cannoni, to a lot of people's surprise, I think made the right decision that if he can authenticate them, say they're real, she lets the texts in.
Yeah.
But the defense doesn't read the texts. Brennan reads the text, and the friend reads some, but then Brennan ends up reading a lot of the bad texts, taking at least some of the sting out of them, reading more texts, kind of either burying them or give them more context to the really horrible texts that Proctor wrote while that friend is on the stand. And then the friend leaves, and we've heard some other rumblings about missing witness instruction, which I want to talk about that as well and get your take on that. But first, Diamantis, Proctor's friend, the defense getting the texts in through them, not reading the text, giving Brennan the chance to read the text on cross. What was your thought about how that was presented?
I didn't like it from the defense perspective. I think it was a lost opportunity. I understand what they're doing. And honestly, to me, it felt like a hedge. They wanted to get the messages in and then kind of figure out later how best to do it. So they get them admitted, they don't read them, and then Brennan sees an opening and does it himself, which I think was the right move from his perspective. 100%. So, from the prosecution standpoint, I think Brennan played that well. He deflated the balloon, certainly, and having a very sympathetic witness read them, very sheepish, very credible guy, obviously, embarrassed to be there, doesn't want to be there, but very honest. He's reading these messages. It's getting out there. It's never going to have the same impact, no matter if the defense revisits it. And of course, by not having Proctor do it, you can't get into the why, what were you thinking, the impact, and what it all meant, as opposed to a very sympathetic person just reading them. And I think the other thing that Brennan did from his standpoint effectively was try to establish these are bad messages. They are inappropriate, and that's why he got fired. I mean, he did his best to get it out that it had nothing to do with the investigation, which I'm not sure I agree with, but from, again, as presenting to the jury, that these are really inappropriate messages, and that's why he got fired. And in that regard, I think he was trying to make Proctor look bad. Again, not that he was a bad investigator, but that he did some things that the jury may not approve of. And I have to imagine that's why he had this guy read the message that was, I mean, really, really lowbrow, having him discuss what Proctor said about the children's father. I mean, that is the kind of thing that never need be made public, but I assume he did that on purpose to emphasize their bad messages. That's why he got fired.
Yeah, I think that there's going to be a couple points here where we're going to hammer Brennan. I'm just guessing, right? You and I haven't talked about this, but I'm just guessing there's going to be a couple points we're going to hammer him. But there's going to be a couple points where we're going to applaud the way he handled it, and this was one of them. He was given this opportunity. He tried to keep him out through this witness. Like a lawyer, he fought like heck to keep him out. Once they were in, he's like, how can I best use these? The defense gives him an opportunity, and he takes it. And from my perspective, he really pacified them. Again, comparing to trial number 1, when they came out with Proctor, I mean, it was like people want to vomit all over themselves listening to him explain this and try to crawl into a corner because he was clearly embarrassed trying to give abbreviations and spell words. So again, with that comparison, I think it looks even worse. I also think, you made a good point saying it was kind of a hedge by the defense, which to me, if we're sitting around a table thinking about how do we do this, if this is your plan, I don't know why you don't just do it last. If you weren't going to read him with Diamantis, just do it at the end, or wait to call him and just get the texts in later. If you're not going to read them, I see no reason to get the text in right. And they haven't had a single other witness read them. So if you were going to have somebody else read them or enter them some other way, fine. Call Diamantis right before you're going to read the text. I don't understand this unless there was mention of we've had to call some witnesses out of order. I think he kind of said that in one of the arguments. So, and I could have been misreading that because it was one of those away from the mic talking to the judge. But so I don't know if they had to call him out of order or what happened. But yeah, the timing of that was not great.
No, and the issue is this too. I mean, at least right now, and of course you have to put an asterisk on this, they still could call Proctor, although it's pretty clear they're not going to, which I do think is a mistake.
Right,
but they know
it's our very next topic. So yeah.
Right. But at this point in the trial, if you said what kind of impact have the text messages had in terms of do you remember them? Where do they factor in all this? I'd say pretty low.
Agreed.
In the grand mosaic of this trial, maybe that will change. They can certainly use them in summation. I mean, obviously, if somebody like Alan Jackson reads them in summation, it's going to be a hell of a lot more powerful than when Proctor's friend was just kind of begrudgingly acknowledging what they were. But at least right now, it's kind of a dud right now. And it shouldn't be because they're powerful.
Yeah. I mean, and again, comparing the first trial, they were maybe the most important, I think. Like they were some of the reason I think some jurors would never vote guilty because that's who's part of their team is Michael Proctor.
And put it this way. I mean, again, I don't know what the witness ordering was, the reasons, but the bottom line is this. Wouldn't you rather have those messages come out after someone like Barrows looks at the jury and says, absolutely not. That taillight, I mean, I know we'll talk about him in a minute, but the reality is what Barrows is saying, again, in the grand scheme of the case, not literally, but to the jury, what he's saying is Michael Proctor's lying and corrupt. He planted taillight evidence. That's the only conclusion you can reach from Barrows' testimony. And if you then put in Proctor's, don't worry about him, he's a Boston cop, all that stuff, I'm just not crazy about the order of all this because I think, if you're only going to get an hour in summation, which I don't know if that's the case or not this time, and the jury forgets what's happened, I think it's really important to connect the evidence in a logical way where it's easy to stack one point logically on the prior and you retain it more. And I think you also use it more in considering the next evidence, where right now the evidence is powerful, it's helpful, but it's a little disjointed and all over the place.
Yeah, the more I think about it, the more I think Proctor may have been the best first witness. Shocking, get the jury up in their seats. They're ready for the next, week and a half or 2 weeks of testimony. And, last time we had a little bit of a disagreement on how we would see it, right? You would call the Higgins, the Alberts, the McCabe entire conglomerate, or at least a chunk of them,
Not
to get
all
a
of them.
lot of good evidence, right? Not all of them, but to get in a lot of the butt dials and shenanigans. And I really think walking past the yard, not seeing the body, is something a lot of us have in our head from the first trial that this jury might not have in their head, because we basically heard it from Jen McCabe and
That's right.
Levinson. That's it.
That's right.
So as opposed to Lucky Laughlin really corroborating what a lot of people said, now he looks like he's on an island, or with McCabe, or was somebody mistaken, which we'll get to. But we have heard, or there's been a motion for this missing witness instruction, which basically is you're not allowed to, as a lawyer, get up there in closing and say they didn't call this witness because this witness is bad for them, or they're scared, or whatever, which is kind of what they threatened to do in opening statements. But instead, and I've got the instruction up here just so I can hit these 4 points, you may instruct the jury, or the judge may instruct the jury, that an adverse inference may be drawn from a party's failure to call a witness when, one, the witness is shown to be available, which we would assume. I've heard some stories about Proctor and Higgins being in rehab or in, another country or something. I'm pretty sure they're available.
They'd have to show they're unavailable too. That would have to be an issue for the judge to fact find and determine availability. And there's been no effort to do that.
Correct. 2, the witness is friendly, or at least not hostile to the party, clearly friendly to the Commonwealth. 3, the witness is expected to give non-cumulative testimony of distinct importance to the case. And some people may think, oh, they've already testified to what Proctor's going to testify. They've already read the text. It would not be cumulative.
Proctor is not cumulative. Higgins is not cumulative.
Correct.
Brian is not cumulative.
Correct. And then number 4, there's no logical or tactical explanation for the failure to call the witness. And again, people are thinking, oh, there is a tactical reason not to call the witness because he's so bad for you. That's not what they're considering. That's the whole point of giving this missing witness instruction. So the defense wants it, which makes it sound like they're not going to call Proctor, Higgins, Albert, McCabe. So first, do you think Judge Cannoni grants this motion and allows them to make this argument?
Well, there's always a wild card where it's discretionary and left to her discretion. I mean, let's be honest, she's not consistent in a lot of things that she does. And, could she hang her hat on saying, well, the witnesses are equally available to you in the sense, and that is true in the sense, they could subpoena Proctor, they could subpoena Higgins, or at least demonstrate what efforts they've made to show that they're not available. But, there is that little kernel in the Massachusetts law about this, that even if they are literally available, if they're just expected to be in the tank for the non-calling party, then that kind of gets excused. So should it be granted? Yes. I mean, should they be able to say to the jury, you should absolutely hold it against the prosecution for not calling these people. You should absolutely wonder why. You should absolutely conclude they're not calling them because, they're going to hurt their case. They can still argue why, they should have called them. It's not like they're literally precluded from mentioning it. But I also think their point, even if they get the charge, which I think they should, I don't know that they will just because of the way it works here, it is slightly diluted because they have put on a case. So, Brennan gets the last word, obviously, in all of this in summation. And, if the defense didn't put on a case, if they just rested immediately, and then they went to town and got the missing witness charge and say, look at this, they didn't do this, they didn't do that, he couldn't push back and say, well, why didn't the defense? I mean, he couldn't, put an obligation for them to do anything. I mean, that would burden shift. It would be reversible error and whatnot, but they did put on a case. So he can at least argue they did put on witnesses. They did call these people, but they didn't call Proctor. They could, if he was so important, they could have called him. So he is allowed to kind of push back a little on this. I don't know. Honestly, I think she should give the charge. I don't know.
I think she should. I think she will give the charge. I don't understand. Here's what I think she'll do. I don't know. I didn't read the names specifically. I can't remember. I know Higgins and Proctor were on there. I don't know if it was just
Brian Albert. Just the 3 of them.
Okay. So, and I was going to say, if they asked for more, I could see her parsing and saying, no, not Matt McCabe, but yes to the. So I think they're the 2 third-party culprits in Proctor. I think that she has to let him do it. I mean, that they've set up their defense like that. They filed all the motions. She knows it. To not do it would just be crazy to me and would be just asking for an appellate issue, not allowing a lawyer. And like you said, you're still allowed to say they didn't call the lead investigator in the case. So that argument's going to come, but it's very important. And lawyers love to say the judge is going to tell you. You're going to hear this from the judge. So when you get instructions from the court, when you get things you can put in front of them saying like, look, this is what the law is. This is what we're arguing to you. This is what they did. It adds a lot of beef to the argument. And I think, listen, Hank Brennan and the Commonwealth, they're entitled to not call former lead investigator trooper Michael Proctor if they don't want to. But they know, just like Karen Reed, she can go give an interview if she wants to. She should and did know that they can be played throughout the trial. Brennan cannot call Proctor, but he should know that the defense is going to be able to make this exact argument if he doesn't call him. And we all know that as lawyers, right? And that's not a surprise. And I think she's going to let him argue it. I think she absolutely should.
She should. I just,
I get your trepidation. I get it. She's made some mind-boggling calls thus far, so I get it.
Yeah.
I wouldn't want to bet on it.
No.
So then let's get to the fact that now it really seems like they're not going to call Proctor Higgins, et cetera. And from my perspective, Proctor was the big swing and the miss. From your perspective, you would have called multiple people. What do you think about that as far as the overall defense strategy? They've been telling us, and Karen Reed's come out on the courthouse steps, we're going to have a much more robust defense this time, a week and a half to 2 weeks. Turns out we might be done by Tuesday, which is like, 7 days of testimony with, breaks and half days in between. What do you think of the overall? They're keeping it simplified. They're keeping it a lot shorter. It seems like they don't want to open Pandora's box and let Brennan talk to Proctor and say, you got fired for these texts, right? Not for doing anything in the investigation. You didn't plant anything. And just hearing him say all that, he thinks, I guess the defense thinks might be too good of an effect on the jury.
I guess. It sounds like they're not calling them, and they obviously have 100 years of experience at high level litigation between them. They know what they're doing. They know things that we don't know.
Absolutely.
For example, they knew presumably what Barrows was going to say maybe a week ago. We're talking about this. We don't know that. I do think, for example, when Barrows comes out with that testimony, it becomes less impactful. I don't even know if that's the right word, in not calling Proctor. It makes it, I don't agree with it. It makes it more understandable because there's some really powerful evidence. To me, there's nothing that Michael Proctor is ever going to say that's going to worry me. And even though I know the majority of his cross-examination is going to be Brennan making affirmative, non-question statements and Proctor saying yes and no, I don't care. I'm getting it out there. I'm having him read the messages, and I'm walking him through the investigation and what he didn't do. I'm right down to the taillight in Dighton, not doing this, not doing that. And I think an underrated part of Proctor, as well as even some of the other cops, is, to me, you need him to finish the impeachment of Jennifer McCabe, who is the most important civilian witness for the prosecution. She denies, she says, I've always said these statements that it seems obvious to us that it's just not true. It's not in these police reports. And you can sit there and read the police report and say, she's crazy. She's obviously lying. But the only evidence is, she gets cross-examined about saying, I don't know what he wrote, but I said this. You need police witnesses who are going to say, I filled out a report, I was diligent, I work hard, I'm careful. They're not going to say that they're not. They're not going to say I'm an idiot, I don't know how to take notes, it's not that sort of thing. And he's going to say, she never said I hit him, because if she did, that would have been critical evidence, because I'm the guy who decided that this was a car accident, a hit and run, after talking to her. That would be his testimony. And I want to ask him why you ordered up a tow truck before you ever went down there. Talk about tunnel vision to fit your theory. And that's another really underrated portion of what Barrows said. It kind of went under the radar because the lead is the taillight, what it looked like. But he also said, they were calling me earlier in the afternoon saying, we're coming down there and we want you there because we're coming to take the car. Not so much interview her. They don't need a Dighton police officer to sit with them because they're going to interview a witness in that town. They want a police officer because they want him to call a tow truck company and help them arrange securing, seizing the vehicle without any substantial evidence, at least at that point, which would fit the defense theory of that. The other thing, if they're not calling Higgins, that I don't understand, because there's a lot that you would be leaving on the table. Now, he's more sympathetic to some extent. I mean, not that much, but more than Proctor. I mean, Proctor is damaged goods. Yeah, I mean, he is dead man walking. Just he's an embarrassment, a disgrace. But Higgins, as far as like the whole third party stuff goes, he's the best candidate. I mean, he's in the bar, agitated, seems to be jawing with them. He's got the text messages with Karen and John. And so there's some stuff out there. But if you don't call Higgins, you're not getting him destroying his phone the day before he got an order. You're not getting him sitting down with the cops, with his lawyer, explaining that, and that I decide what text messages you get. And I went to my friend at the FBI and he helped me handpick only the messages I want you to have. You're not getting any of his first testimony explanations, which don't make sense. There's two other key points with him. Well, the butt dials too, you wouldn't get, but there's really two other key points that to me, I would never leave on the table. For whatever reason, the way Brennan has decided to do this, really, Jennifer McCabe, as you said, is the only witness who's going to say nobody came in the house. There is that Sarah Levinson, but she's kind of like, not really compelling one way or the other. Higgins told the FBI, this came out in the first trial, another guy came in the house and he was 6'2", brown hair, basically the description of John O'Keefe. And he said it wasn't him, but you're kind of leveling it to 1-to-1. Higgins and Jennifer McCabe are inconsistent on that point, which could mean that Jennifer McCabe was lying, or it could mean that maybe this man, whoever he was, went to a different portion of the house that she was unaware, which also could support what the defense is alleging. And then the other point that I think they need to drive home more, and it may be disjointed to the jury right now, is the Jeep. And, the Jeep has always been one of those real oddities. Jennifer McCabe is adamant Higgins's Jeep was there in front of the mailbox. The two kids who drove up, there's no Jeep, so whatever. But with Higgins, if he says his Jeep was there, which he's kind of going to have to do. I mean, you remember that kind of ridiculous story, how I was kidding around and I plowed the driveway even though there was no snow. I mean, he's really all in on the Jeep being there. And if the Jeep is there, if that's credible, that undermines Welcher, because Karen Reed would have probably smashed right into the Jeep if given on his calculations. If the Jeep is not there, then Higgins and Jennifer McCabe are almost certainly lying for some reason. And from the defense standpoint, either one of those works for me. So I'm not sure why they wouldn't call Higgins. I'm not afraid of Brennan putting words into his mouth on cross-examination. I would do it.
Yeah, to me, I would be 100% in on calling Proctor, like I've been the whole time. Still would after Barrows. I get what you're saying about Barrows, but it sounds like you would still call Proctor even after Barrows.
I would.
Yeah, because, I mean, you've already gotten Yuri Buchanan, Proctor's mouthpiece. He's already said everything they're going to have Proctor said. So it doesn't even matter. You've already gotten Brennan talking about Proctor was fired for the texts with Diamantis. All of the good stuff the Commonwealth can get out for Proctor has come out.
See, here's the thing. The first trial, I think everyone agrees, they went way overboard with proving what happened. And you don't want to do that, obviously. But the threshold of the center point of the defense is that the police framed her, they're incompetent, or it's kind of a hybrid between that, okay? And if you establish that credibly, then she's not guilty, clearly. I mean, if the jury resonates with that. So there's a difference between going all in on credible evidence of incompetence and framing without suggesting what it really means other than that about who did what. That's different than, trying to prove who did it. But if you don't call Proctor and you don't call Higgins, then you're still putting it out there effectively that she was framed, but it's a hedge. This is the issue that you go all in. And the reason you do it is because of Barrows and Lucky. I mean, what they did the last 2 days is have two witnesses who were very credible, certainly demeanor-wise. And, you have a plow driver who's like, there was no body there. There has to be a body there if you believe the prosecution. Has to be. And then you have Barrows saying that taillight absolutely did not look like the state police alleged it looked like. That can only mean one thing. They framed her. So why would you do this 65%? I mean, you have it. I mean, to me, I would forge ahead. There's nothing. I mean, what's Proctor going to say? I didn't do the taillight. I didn't do the tail. Who cares what he says?
Yeah. Proctor can't hurt you. And I would agree with you. Your theme is bad cops, right? Regardless whether it's intentional, negligent, whatever, it's bad cops, and you're not going to put the worst cop up there. Like, you put Nuttall up there, and I get it. You hit his credibility. He does not seem like a Proctor level bad first responder, right? It's just not the same thing to put some of these guys up there. Even some of the ones they have put up there that are just bad, they're just not Proctor level bad. So if you're going to try to prove bad cops, I'd put the worst cop up there personally. And then
you also have to, I don't mean to cut you off, but
you're good.
This point. I don't think they have to, based on the opening statement. I mean, I think there's enough out there where they're not writing checks they didn't cash, but they got up there in the opening statement.
They showed the checkbook. They might not have written the check, but they showed the checkbook.
They said Michael Proctor is a cancer that metastasized throughout this investigation. You have Barrows, he said what he said. You have Lucky, he said what he said. You have Dr. Russell, who's saying it's not consistent with a car. You have all this stuff. But to me, it feels like there's the risk of you're still hedging. I mean, by not calling the nucleus of this misconduct. I mean, it all flows. I mean, you've literally called him a cancer that's spread.
Yeah.
So how about we conduct the surgery in front of the jury and scrape off the cancer and slice and dice him, which, by the way, whatever, again, Proctor can say, and even if they have to do it via a direct and he's not a hostile witness.
Which was crazy. I mean, any was a hostile witness, but.
Right. Yeah. I mean, look, he's obviously hostile in the legal sense. Because of what he did. But whether she allows that or not, I literally can't fathom why you wouldn't call him. But and the only thing I can come up with is they know what they're doing. They do. And they're privy to things that we're not. And it's not the kind of thing that they would do lightly. And, I guess you're really not going to know until the evidence is closed whether, what they evaluated, whether it was smart or not, or smarter, I should say, because there is a reasonable view to not call him. You've got the boogeyman. They didn't call him. You hope you get a missing witness and, all of that. But I with him and Higgins in particular, I don't see how you don't do it.
Yeah. So with Proctor, we're on the same page, 100%. We would call him, but I completely agree with you that they know more than we do. And I'm not. Yeah. Sometimes we have these conversations, and people are like, "Oh, I want to hear what lawyers think about it." Like, "Oh, you think you're better than this?" Like,
no,
we're just having conversations of how we look at it with the limited knowledge that we have about the space.
That's really it's limited. I mean, we're having an exercise that's interesting. People find it interesting, but we don't know what they know.
Exactly, and we're trying to figure out the reasons why they wouldn't call him, but it's not like they haven't taken risks, right? Diamantis was a risk. We're about to talk about Dever. That was a risk, and we'll talk about it. But real quick, I just wanted to say on Higgins, I talked about how I probably wouldn't call him and Albert, but I could be convinced. Like if we're sitting there and we're trying this case together and you're like, we can get these 6 things out of Higgins. It's important. Here's the risk. I could be convinced to call Higgins, right? Because I do agree with you that normal people, lay people, which are the jurors that you talk to about this case, when they hear he went on a military base to destroy his phone and they're like, come again? This cop had his FBI friend and went to a military, like he knows how to destroy stuff. Clearly, that's pretty big.
the other thing is this: we're told it's a young jury, okay? So they're going to be techno experts, iPhone experts, all of that. They know what butt dials are and what butt dials are not, okay? Do they periodically happen? Yes. However, these two guys had a butt dial conversation a minute apart. They both deny it, and there's something else that they really want to tether that to. The butt dial is at 222 and 223, and they're very much trying to establish something else happened at 227. I mean, that's a hell of a timeline coincidence. Destroying the phone, a federal agent, after going to his friend at the FBI, the man in the house, and the Jeep. I just, you're arguing that Higgins is a potential candidate for having done something nefarious. You're going out of your way to show something's going on in that bar between him and John O'Keefe. You have those weird text messages between him and John after the ones with him and Karen. They even did a nice job yesterday in having a neutral witness essentially narrate as much as she could the confrontation or whatever it is, but they even went farther and they showed the affection between John and Karen, and introduced a portion of the video which appears to show Higgins looking right at it at a time he thinks, well, Karen, that kind of thing. And then he sees that he's being ghosted. I mean, there's so much there. And I'm just thinking, you have this guy against the ropes and you're landing blows and he's tiring. And I feel like, they're walking away instead of finishing him and finishing all of this. And again, they have no burden. I mean, they don't have to establish this to a certainty. They just need to create doubt. I think there is doubt already, but there's so much meat on the bone with Higgins that the jury's never going to know. And I would hate to go to a jury with them not knowing that, because it's powerful stuff.
Yeah, and it wouldn't have to be a 2-day direct. Like, you could get that out of an hour probably from him, get what you need to get, and then let Brennan. His crosses have been so long, some of them, that I think sometimes they lose effect, which we're going to get to with another witness. But let's get to Dever. So the defense calls Dever, Boston cop, former Canton, was there. She makes a statement, I guess, at some point that Berkowitz and Higgins were with the car before 3:45. The commissioner calls her into the office. She realizes what she said was a created false memory. And so now she refuses to say it on the stand to Alan Jackson because that would be a lie. And she doesn't want to lie. And she checked with legal and this is not perjury. And she did all that before she came. Okay. So what I want to know from you, because I said I thought she was a horrible witness. She's totally not credible, just bad witness all the way around, bad demeanor. But the defense chose to call her. And if I'm the defense and we're sitting here having these discussions, they're not calling Proctor and Higgins, okay? Which I think Proctor is not just a home run, a grand slam for them. And Higgins is at least a triple for them. So I just would not have called her. And after listening to her testimony, I did not think it was effective for them. I don't think she was crushing for them. I don't think she was great for the Commonwealth. I don't want anybody to be misunderstanding what I'm saying at all. But they are obviously making big game time decisions with which witnesses they're going to call. And they're choosing not to call people like Proctor and Higgins, but they choose to call her. I don't think they should have. What did you think about her testimony? Because you thought she was great for the defense. Let's hear why.
So calling her, I mean, obviously the point they got out from their perspective that they wanted to get out was, I saw Higgins and Berkowitz for an extraordinarily long time in the Sally Port the day of this, before any taillight was recovered. And even I being her, thought this is weird and shouldn't be happening and whatnot. That's what they wanted to get out.
So before you go, do you think that's even possible at the timing that she said in the timeline?
Yeah, I mean, sure it's possible. I mean, she was there that day. There was really no evidence of where she went after, and then she worked a double shift or something. Both sides kind of left that hanging, which I'm not sure I understand. That different issue. I don't get that. But that's the point they wanted to get out. And what that tells me is this. It tells me they're not calling Higgins, okay? It's another sketchy thing involving Higgins. And it's also a sketchy fact involving Berkowitz, who, of course, is deceased and was apparently medically unavailable at the first trial or whatever. And I think the intention is to go back to a lot of this taillight sketchiness about it being found day after day. And one of those examples was, Chief Berkowitz just driving around one day and look what he found. And I think eventually they're going to tie it to that. So I think by calling her, they're really telling you they're not calling Higgins, which whatever. Why do I think it might have been more beneficial to them than you beyond that is because her behavior is just a perfect illustration of their theory about the way the police acted in this case. And, her demeanor was just outright shameful. And you want to feel sorry for her in the sense that this is a young kid, young cop, female cop in a predominantly male profession, not as much as it used to be, sees something bad, tells somebody, and she's getting the pressure. She's out of the Canton police shortly after that, ends up in the same department that John O'Keefe was in. They later catch wind that she may be a defense witness. She told the FBI information, which is clearly favorable to the defense, certainly adds nothing to the prosecution. And then this, nobody kid cop gets summoned to the commissioner's office of a very large department and is told, we have your back and you do the right thing, which is, we all know what that means. So on the one hand, you want to feel sorry for her to be put in that position. That kind of pressure is just remarkable. She goes on the stand. She's clearly being held hostage, in my view, by the blue wall, if you will, and the pressure being put on her. But then she just dives into it in a point where her demeanor was so ridiculous. It was childlike at times. I mean, she was literally like a petulant child about just like, you can't remember my name. I can't remember this.
Horrible.
And she starts with this false memory nonsense, despite having so much detail in her false memory, to the point where she has discredited herself beyond this case. I mean, she's become kind of a laughing stock, and, she's going to be, those Google hits on this are forever, unfortunately. You know what I mean? Like, they're going to remember this. And so I think she ends up helping the defense in some ways, both by, they're going to believe that she admitted, I told the FBI that. And that's what I thought was true at the time. So they get that fact, and then they get her demeanor and the way she's being held hostage and her overt nastiness, where it adds to the police are out here basically trying to frame her. So I think in that vein, it helps. I mean, certainly it's not the most compelling witness. It is a risky call, but to me, the reason they called her was because they're not calling Higgins.
Yeah. And that's, again, a mistake. I think if I'm looking at, do I call this witness Dever or do I call Proctor and Higgins? Because I think they would have taken care of everything she said. Any good that came from her, I think would have come from Proctor and Higgins times 1,000. But I also do think, and again, maybe I'm just sensitive to hearing from jurors where they just believe one side or they believe another side and they kind of go with them through the whole trial. But there have been multiple times throughout this trial where Brennan has gotten witnesses to say that defense team or a blogger that is favorable to the defense team, which we're going to talk about in a second,
maybe
to
some extent. We'll talk about it to some extent.
Correct. To whatever you want to say, right? I'm just saying we heard the blogger's name in trial, that they either threatened you with perjury, told you what we wanted them to say, highlighted a report and told you what parts to say, told you to change your testimony, talked to you in the middle of your test. Those defense lawyers are the bad guys. And what jurors don't like about us defense lawyers, we're coaching our witnesses. We're forcing people to say what we want. While I'm sitting over here as Mr. Brennan, you've never talked to me. You've never met me. We've never spoken. I didn't tell you what to say. I just asked you to tell the truth. And I do think some juries may buy that. And this witness was perhaps the most, like you said, diving in full force to, you called me, you threatened me, you wanted me to tell a lie on the stand. And I do think that there is a chance that has a pretty serious negative effect on the jury. Maybe they just throw it away. And maybe they just say,
I thought that part was ridiculous. I mean, again, I'm not there. I don't see the reaction.
I mean,
Great.
yeah, I
But
don't know.
I don't think that this police officer claiming that you threatened me with perjury and told me if I didn't do this. I mean, my take on that, and again, we're lawyers, there's some degree of bias, we deal with this stuff,
Correct.
that she just came off as a complete clown by alleging that, especially because she's a police officer. I mean, usually when people lie, there are kernels of truth as opposed to making something up out of whole cloth. So could there have been a discussion where they said, you told this to the FBI, okay? They told you it's a federal crime, 18 USC 1001. Every lawyer knows it. That, if you make a material misrepresentation of fact to the FBI or the U.S. attorney, whoever, any federal official, it's a crime. And, this is what you said. And if you're not saying that now, that could be deemed a federal crime. Did she take that because they advised her what happened?
We've done that in depositions and in trial.
Right.
I mean, a million times.
What
It's
I'm
like,
saying is she then morphs that into, you threatened me with perjury. I mean, I just found her to be ridiculous in a lot of what she's saying. Look, I don't think at the end of the day, Dever becomes a big deal other than in summation, when they're talking about the mysterious tail of the taillight, how it just shows up on the lawn. I think the key is going to be Berkowitz in the Sally Port when he's supposed to be recused from the case with his friend Higgins, who shouldn't be in the Sally Port at all, a long time. And lo and behold, Berkowitz finds taillight. Higgins is doing these other things. And that's the value. It just links back to that.
Yeah, I think that in summation is where she is going to be most important. I don't think she's going to be a key witness. And again, I'm just saying, like, we're picking and choosing what defense witnesses to call. I just would never pick her to call. But I do think Brennan's going to get some mileage out of her in summation too, to say they're threatening people with perjury. And of course, that's what they mean. They didn't obviously mean they're going to, they're the ones that are going to write the charges as private criminal defense attorneys in Los Angeles. But all of us have said, you said this under oath. It's a crime to lie under oath. We all said that to witnesses in depositions, trials, witness prep, whatever it may be.
I see. If I'm Brennan, I mean, look, if you start in with that, I don't think it's believable. I think it's almost over trying the case if he goes into a vigorous defense of Dever, as much as he says she made a mistake and she acknowledged it and she didn't remember it. And you gently say, there's no reason to credit what she's told the FBI. I mean, if they go down the path of saying that she was exploited and I just think he's becoming a clown. I think you're right. That's what he'll do. I mean, I think he's so aggressive on every point and he just throws everything out there that he'll probably do it. I wouldn't. I would just kind of shrug my shoulders and say, look at her. She's just not reliable. She's not important to this. There's no, and by the way, the evidence is technically she told the FBI, not that's what happened. So technically speaking, she did not testify that I saw these two guys in the Sally Port. Her testimony is, I did not see these guys in the Sally Port, but I did tell the FBI, but I was mistaken. So to me, it would be a more nuanced dismissal of her rather than diving in about, Alan Jackson threatened her with perjury. Because look, the reality is the jury probably likes him, okay? And they're probably not buying into that, and it sounds desperate to me.
Yeah, well, whether it's desperate or not, whether it's going to work or not, I absolutely think it's what Hank Brennan's going to do because we know what's coming.
I do too.
Right?
I believe he'll do it.
We don't know what all the witnesses are coming, but we know Arca's coming, and we know he's going to talk about Signal. We know he's going to talk about disappearing or deleting text messages. We know he's going to talk about people feeding them information during trials when they shouldn't be feeding them information. He is creating a theme of these defense lawyers break the rules and do all the things you normal people who aren't lawyers that you hate about lawyers. That's these guys from Los Angeles, right? Because Jackson asked, I think it was Barrows. He goes, I'm from Los Angeles, right? I don't have an office here or a house here. So it's like, I think that's definitely going to be Brennan's theme. And this gave him another, nut to put on that argument. I really think that he is going to use Dever for that. I just would have preferred to not have that type of stuff come up as a defense attorney because I think I could have gotten it better out of other witnesses. But again, they know better than us. They're better than I am at this. Okay. They're better at all of it. They know more of it. They've done it for longer. So I'm not saying it for those reasons. I'm just saying, as I looked at it, I cringed a little bit during the cross-examination and was thinking there are better ways to get this information out than with Dever. But I think you made really great points about what positives can come from her and what the defense is going to be able to do and use to tie their case together, especially if they know their strategy is, we're not calling Higgins, we're not calling Proctor, so we got to get some of this stuff out elsewhere, and they chose her to get it. So, and hopefully they still get that missing witness instruction, because I think they deserve it legally. But we'll see. So I think, you make great points. I'm not surprised. Most people disagree with me about that. Everybody online, thinks the defense can do no wrong in this case. But I just, as I'm looking at it, they have so much good stuff. There's so much good stuff for the defense in this case, so much meat on the bone that's not a bite I would have taken.
It was a hell of a gutty call. I mean, whichever way it was, to call someone who's going to be that difficult and duke it out with you like that is interesting. On the other hand, again, does every decision have a strategic reason that doesn't become evident until the next witness, who was Barrows? And then you get that dichotomy, right?
Oh yeah.
Active duty cop 1 is going to fight you to the death and just argue. Active duty cop 2 is going to be the most cooperative when he shouldn't be. He shouldn't be a defense witness. So maybe that was part of it too, to kind of enhance how good Barrows was in terms of his integrity, trying to show that Dever was just difficult for the sake of being difficult because she wears a uniform.
Yeah. And I mean, Barrows was next and he was A+. Before we saw Lucky Laughlin, the biggest difference from trial 1 to trial 2, because I remember thinking, okay, cracked with a piece missing. I guess technically that could be the same thing as what the Commonwealth is showing us. And maybe it's just a big piece, but he thought it was one piece, not 47. Some people say cracked instead of broken. It was not, the difference was not explained nearly as clearly in trial 1 as absolutely not. It was absolutely different. This was the piece of the taillight missing, a dollar bill size, 6 inches by 2 or 3 inches. Couldn't have been clearer on direct. Potentially a haymaker. Like, to me, if I'm a prosecutor and a cop tells me that, I'm like, boys, I don't know what happened to the taillight. I'm not accusing you of anything, Michael Proctor, but I can't prove this case against Karen Reed at this point.
I have a real, before we even get to that, because I think too, he was essentially the death blow to the case, but I have a real problem that the jury will not be aware of. But again, in assessing the entire ethics of that office, you can't ignore this as lawyers. Barrows testified as a prosecution witness at the first trial. He prepared a small report about, what he did in this case. So he met with Adam Lally before he testified. He didn't put him up there cold, just literally, I don't know what this guy's going to say. So Barrows says, there's a crack in the taillight, which is technically different than what the state police are claiming. It's blown out. Half the taillight is gone. His report is not consistent with that photograph that the Massachusetts State Police took a few days later and their evidence of what it looked like. So what prosecutor interviews Barrows and says, tell me what you saw? And let's assume he says, I saw a crack. And they say, well, can you describe it? It is impossible to me that Adam Lally would not show him a picture. I'm talking a year ago or more. Mm-hmm. The famous picture. Did it look like this? Now let's assume Barrows says, no way. No, it just had that one little dollar bill size piece. That's Brady material. That is as exculpatory gets. None of that is ever disclosed to the defense. So now presumably Lally is aware of this. He calls him at trial and on direct, and he probably calls Barrows, by the way, so the defense doesn't, because he knows, and again, the defense would be hedging by cross-examining him, not knowing what he would say. So on direct, he says, well, there's a kind of a crack, which is, again, not really consistent with the Proctor, Buchanan, McCabe, Roberts description of the taillight. But Lally never asked him to describe it. Obviously, if Barrows was going to be favorable to the DA a year ago, they would have shown him that picture and he would have said, oh yeah, I was missing that piece. That would have been devastating testimony to the defense. Close to a knockout blow for them. He never did it. He never asked him to expand upon the condition of the taillight. So now here comes the defense. They don't even cross-examine him, obviously, because they don't know what he's going to say that he said in trial too. And they get a little bit of favorable testimony, but they don't have the courage, which I agree with, to show a picture. Because what if he says, yeah, it looked like that? They're screwed. Okay, fine. So he never gets asked. But he knows the case is over. He does watch the news. Whatever. Everybody watches the news. He knows that, wow, that taillight didn't look like the way it's been portrayed. So what happens between trial 1 and trial 2? Does anybody in the DA's office go to him? No. That doesn't really make a lot of sense. They don't even contact him. What does he do? Not only does he agree to talk to the defense, he goes to the hotel in Boston to meet with them. I mean, this guy is volunteering to testify. Okay, he has something to say that clear. I'll take a subpoena. I'll do this. On-duty cop. And he is now adamant that the taillight was not shattered, just that one piece. He obviously made a mistake about seeing the photo at trial. Not the biggest deal in the world, but, he was wrong about that, no question. Very good cross by Brennan, by the way. But the point is, before you even get to the impact, how does anybody who does this for a living and understands how prosecutors interview witnesses, how they examine witnesses under oath, and again, I'm going to trial 1, how does anybody seriously believe that Adam Lally and others knew that Barrows, if pressed, would torpedo the case and say what Proctor and Buchanan are saying about the taillight is not true? There is a real ethical concern that I would have here about their burying this fact. So moving on to, the impact of trial 2, nevertheless, the guy says the taillight was intact except for the small piece. And that is such a clarifying thing for the jury, black or white. If he's credible, if they credit his testimony, you have to believe they framed her. I mean, you have to. You can't. We are at that moment of black or white, either or, both can't exist. And he does seem credible, even though he made a mistake. And I'm not impressed by showing him the video and asking him, what does it show? That's for the jury. I mean, they're really, I don't know what those videos show. The one going onto the tow truck, to me, shows what Barrows said conclusively. Some of the other ones, there's reflections. I don't know.
I wouldn't want to base, from the beginning, I wouldn't want to base the whole case on any of those pictures or videos because none of them are perfect. And either side can take them to me and do their lawyer thing and tell me they show exactly what you say they show.
I agree. So putting that aside, you're left with the testimony. And this is a guy who is the only police officer who's going to testify at this trial who literally has no skin in the game. And he's being called by the defense. The jury knows he was a prosecution witness and he knows what he said. And so you sit there and you say, if he's credible, then the car accident could not have caused that damage. They could not have found those pieces the way Buchanan said he and Proctor and Berkowitz did. The other benefit in summation you get out of Barrows is it also means Jennifer McCabe could not be telling the truth about what she saw. Kerry Roberts is not telling the truth. So, I mean, to me, when you look at this through the lens of reasonable doubt, credibility of witnesses, I don't know where they go from here after Barrows. And then to follow him up with Lucky, that's powerful stuff.
Yeah, I don't know. And this is why everybody should understand why lawyers hit credibility of every witness, every chance we get, because the Commonwealth could say, oh, well, it's 4-1, right? We've got Roberts, we've got McCabe, we've got Proctor, we've got, Buchanan or whoever saw the taillight and said it wasn't completely busted and they only have one. So it's 4-1. But that's where you get into the credibility issues, right? Can you believe them? Who has a reason to lie? Who has a reason to push a certain narrative? And that's why that's so important. And this coupled with the chart, right? The glass chart that Jackson put up. I mean, they've got some really strong and simple to follow reasons why, wow, maybe they thought Karen Reed did it and they just wanted to make sure they had enough evidence to prove it, but they're really pushing towards the cops were doing things to make sure there was enough evidence to point at Karen Reed, regardless of if that evidence was legitimate or not after the fact. And I think, I thought it was over, but Hank Brennan did the only thing a lawyer can do, and that is hit Barrows' credibility. Maybe your memory's not as good. Maybe it's different. You testified different at trial. Do you remember what you said at trial one? No, you don't really remember all the specific trial one. That's because sometimes people's memories can be faulty. And because he was such a calm and fair and neutral witness, he was like, yeah, I was wrong. Yeah, my memory's not perfect. Yeah, I forget things. He did say, but still, I know what I saw, and that's not it. But you said he had a good cross. What percentage of the credibility knock do you think he got on Barrows? Because I do think there was a percentage. I don't know how large percentage it was.
He clearly was wrong about seeing the photograph at the trial. Again, he has seen the photograph. He's wrong about that. The problem, again, is for Brennan that Barrows remained credible. He didn't get shifty. He didn't get, all weaselly. He didn't fight and argue. He acknowledged because he has no skin in the game. Mm-hmm. Was he a little embarrassed? Probably. But he also said, I know what I saw regarding the taillight. Okay. And that's kind of a big thing. And also what can't be underestimated is the redirect examination by Allen was perfect. Okay. The analogy about, the birthday, but you don't remember, what day of the week it was beautiful, as you remember the damage, but you don't remember when you saw the photograph. It might have been sometime else. And are you still clear about this? So did he take a minor hit on he's not infallible? Maybe, sure. But the bottom line is he is no skin in the game. He is adamant about the condition of the taillight. He was never asked at the first trial. Don't underestimate that. He's not inconsistent on the taillight, okay? Nobody asked him, okay? And to me, the big deal is, why would the prosecutor not ask him at the first trial if they called this guy and he was going to support their position? That makes no sense. It's real sketchy. And I think, to your point, Barrows is going to be bolstered by some other key facts. And that this is probably the death blow for the prosecution. First of all, he's going to be bolstered by the ARCA guys who are going to say, I don't think this taillight is shattering and doing this the way, you guys all claim. That is huge corroboration for Barrows. But there's something else that you just mentioned. The glass on the bumper, okay, does not match John O'Keefe's glass. There's no explanation for how it got there. And then you come to find out the only thing it matches is the other piece that Michael Proctor claims he found in front of 34 Fairview a few weeks later. Mm-hmm. That ain't good for the prosecution when you start marshaling all that and say, what seems to be going on here? So to me, Barrows he survived. I mean, I said this at the time. The only way that I can even see that there isn't going to be reasonable doubt just from Barrows alone and what supports him is if they literally knock him out and have him say, I don't know. And they didn't do it. And that's not to take anything away from the cross. It was good. It was really good. It's probably the best cross he did in the whole case.
I agree.
But it's not enough. And, what resonates by the time of summation is the only neutral cop in the whole case just completely nuked the entire prosecution theory. Mm-hmm. And there's no burden of proof on the defense. How do you get around that?
Yeah, and I think Hank Brennan's cross highlighted a lot of the problems with all of the law enforcement witnesses throughout his case and why they wouldn't take pictures, as if he thought Barrows should have been the one to take a picture. Just makes no sense.
Right. It doesn't. To not call Proctor and to come after this guy for doing investigative work. Yeah. And it also shows you are in the upside down when the most important cross-examination for the prosecution in this case is trying to attack the credibility of a good, honest police officer, and the one attacking his credibility to salvage their case is the prosecutor. That should never be happening in a criminal case.
Yeah, I agree. Then we get to Dr. Russell, who A+ witness, great background. I thought the biggest difference here was how much more she was allowed to say in this trial than trial number one, specifically that this was inconsistent with the car accident, which I think was just as important, if not more important, than all the dog bite stuff that she was able to say, because they didn't really have another medical expert, and the Commonwealth has no medical expert that says these injuries are consistent with injuries caused by a car accident. And I thought Brennan's cross, if Barrows was his best cross of the trial, I think this was his worst cross. It was so ineffective. He looked like a jerk for a very sympathetic witness. Overall, I thought it was kind of like home run after home run here for a couple witnesses for the defense.
Yeah, I think obviously Dr. Russell was a 2-for-1 destructive force for, the prosecution case. I agree. The dog bites, it's a secondary thing. I mean, the larger point is not consistent with a car crash, which is the whole theory of the DA's case. And at that point, whether they're dog bites or any other reason becomes secondary. I mean, if it's not from the car, Karen Reed walks out of there free. End of story. And I think you said another really important point that people have to realize: they have no way to impeach Dr. Russell. I mean, they have no medical person. They have nobody to talk about this. I mean, the only contradictory evidence, if you can even call it that, is having Dr. Welcher cosplaying as John O'Keefe saying, look, there's blue paint on my arm, so it could have been from that. I mean, that's not very...
Our medical expert, Scorty Bello, agrees with Dr. Russell.
Exactly. So the other thing, his cross was terrible of Dr. Russell, because he was inviting her to just pile on with these open-ended explanations. She would even say, do you want me to explain? And he would say, go ahead.
Yeah,
and
I know. Crazy.
She's offering actual medical explanations for why Karen Reed might have been running around saying I hit him, even if it weren't so. She's explaining why this can't be from a car, but could be from this. And he's inviting this. He's aggressive, with an expert, which there's no reason to be aggressive with her. And yeah, no, I thought she was a home run for the defense just for that reason. Again, under the lens of reasonable doubt. And I think when you start stacking these witnesses, Dr. Russell, Scorty Bello, obviously.
And then even Walsh, he asked her about Walsh as if he was going to impeach her, but Walsh basically said reasonable doubt. Undetermined.
Right. Yeah, that was not helpful.
Car accident. I mean, that was horrible.
Yeah, that was not good. And again, you start stacking witness after witness, the last few witnesses you've seen, and you just start to wonder, and you say, where is the beyond a reasonable doubt? I mean, it doesn't matter whether maybe she did it. I mean, if they're thinking like that, she's not guilty. Like, end of story.
Yeah, and then we get Lucky Laughlin, who, again, we've talked about him a little bit already, but nobody the time. I thought Lally actually crossed him better than Brennan. I thought Lally, and maybe it was Lucky Laughlin's responses the first trial that gave Lally more leeway to try and hit his credibility and, the differences in his timeline and testimony. But I thought it was overall ineffective, the cross Brennan had on Lucky Laughlin. And I thought the direct and the redirect cleaned up basically everything that he had. And the best thing Hank Brennan got was, you have outside pressure from a blogger and he's causing you to lie in this trial. Basically that's the best thing that Brennan could come up with for cross.
Yeah. I thought Lucky Laughlin was an A+ for the defense, and that the cross-examination of him was flailing and pretty ineffective. I mean, first of all, if you take Laughlin's demeanor as a whole on direct and cross, he passed the credibility test in the best way you can, which is his demeanor did not change from direct to cross. And if you didn't know who was asking questions and they just played some snippets for you, you wouldn't even know who the lawyer was questioning him based on his demeanor. Okay. He was even Steven. He was calm, and the substance of his testimony is devastating. I'm driving Franken truck, lights up the night sky perfectly, and I went by there. And if the best Brennan has are, well, you might be a little off at the time you were there, let me tell you something. The DA's theory is by 12:32 until 6 o'clock in the morning, John O'Keefe is lying on the lawn for all to see. And I don't care if Lucky Laughlin comes by at 2:30, 3:30, 4:30, 5:30.
I don't care
if he comes by a couple times and says, I light up the lawn, and he's not there, guess what, Mr. Brennan? And that's credible, you lose. It doesn't matter. So I think that was, I get it. You got to try something. And then, he comes in with this stuff about the blogger that we're talking about, and talk about blowing up in your face. I mean, if the idea was to suggest that this guy was intimidated into giving favorable testimony to the defense, you need your head examined, because the evidence could not have been clearer that Lucky spoke to the defense within days of the incident and said, nobody on the lawn. Nobody in the world had heard of the blogger that he's referring to about this case anyway for a year and a half. And his story didn't change. So how could he be intimidated into telling a favorable story for Karen Reed that he told her lawyers within days of the incident? So that was bad. And then on top of the fact, when he confronted him with all that evidence, he very calmly, never even flinched, and said no. And he even said, I follow him. I watch him. I mean, which was kind of weird. And he even said at the time I was first contacted and I wasn't, didn't want to talk to anyone, my wife had just passed away. I mean, you really should be careful when you start asking those questions and you get that. And even then, and I don't know how much the jury cares or doesn't care about this, the way Brennan handled that was like, well, I'm sorry for your loss, but this. I mean, it was really,
you don't want to be in that spot as a lawyer. You don't want to be.
But he was also heartless about it. You might step back and say, Mr. Laughlin, I'm sorry for your loss. I didn't, whatever. And just take a pregnant pause, take a breath, and go. Instead, he doesn't flinch. He doesn't skip a beat. Says, I'm sorry for your loss, but this. And it just, I don't know if that resonates with the jury. It just came off really sleazy, I think. But the bottom line was he didn't lay a glove on this guy. And, the fact that there are pictures of him with people who support Karen Reed after he testified, look at this guy. He's as earnest as it gets, okay? He clearly doesn't want the attention. But he walks out of court after the last trial. Bunch of people are like, oh, can we take your picture? What is anybody going to do in that situation? You're going to do one of two things. You're going to do it and stand there. And by the way, if you look at the picture they introduced in the evidence, he's uncomfortable. They're all got their arms around. He's standing like this. He's not comfortable. And the only other alternative would be like, no. I mean, which is weird. So he did it.
And do you really want the jury to know that all the public supports?
No.
Like, I don't want to get that out if I'm Brennan. I mean, Brennan doesn't care, right? He'll walk out there, I'm the Dark Knight, right? And it's like lawyers don't care, but normal lay people sitting back there, usually we don't want them to feel the public pressure of which side it's on. I'm
a cynic, okay? I think the stuff that you saw that we're talking about now with the blogger to impeach Lucky Laughlin was more a stunt than anything else to get it out in front of public, to appease a certain segment of the population. And frankly, the world is watching. Everyone in Norfolk County is watching. And to put it out there for maybe future jurors on a future case or cases and imply that he's harassing witnesses and intimidating them.
Okay.
More than it was designed to actually have Lucky Laughlin say, you got me. You're right. I'm only saying this because of that. Let's be clear. There are no charges for witness intimidation for anything that happened to Lucky Laughlin, okay? I think that was a stunt as part of their obsession of trying to hold someone else accountable for what they believe is witness intimidation, more than it had anything to do with effectively cross-examining Laughlin, which it didn't do anyway.
Yeah, and then we finished with Miss Kolithas, who I thought maybe the most important part of her is we've seen so many people basically that don't seem to like Karen Reed. Yes. A lot of bad mouthing of Karen Reed. Even John O'Keefe's mom doesn't seem to like Karen Reed. finally we have somebody get up there who's like, no, I loved Karen. I want to talk to Karen. She was cool. Yeah, John kissed her on the forehead. They were in love. She kind of, like you said, gave a rundown of the waterfall, but just making it be like, no, there are people that do like Karen Reed. She's a real person too, humanizing her. Again, not a home run for the defense, but a 2-second cross. Literally nothing the Commonwealth could do to touch her. I thought, again, a good decision for a witness called for the defense.
Yeah, I agree. And, it's funny because there was some discussion, online from, a lot of the haters, the whatever, the anonymous lawyers and types who, oh my God, what a desperate, stupid thing to do. And what I tried to explain to anonymous lawyers or whoever these people are is there is a nuance to trying a case. Okay. There are nuances. Not every witness is the knockout blow. There is a method to the madness. And this witness was an opportunity for the defense to do a few things. Not that it's going to carry the day, but you're right. A lot of people don't like Karen Reed. And let's be honest, she's not testifying. I mean, we don't know that, but she's not testifying.
No.
And she's not the most sympathetic person, certainly in some of those clips. So how do we sympathize her? Well, we have a friend of hers who was out with her that night with John O'Keefe and Jennifer McCabe and basically says, I love Karen. That's how you sympathize her. That's a smart thing to do. That is a nuance that helps the defense. And then you get as much out of that as you can. And I think they did it really well. So she says, I really like Karen. Okay. More importantly, I'm there with her and John O'Keefe. And what does she say? They're getting along great. So much to the point that I saw something I've never seen in terms of affection. Him kissing her on the head, which kind of negates to some extent this idea that she's this conniving, manipulative, whatever. Then they also
Brennan was going to cross her and say, well, you don't know what they were text messaging. You don't know what happened earlier. I thought that was going to be the cross, and he didn't even do that with her.
Well, I think he did the right thing. Get her out of there. Nothing good is going to come from this. I think that was one of the smartest things he did. Just get her out of there. But I think what the defense did very smartly, they exploited it for all it was worth. So not only do they find the video of the kiss on the head, but they've got Higgins looking right at it. And by the way, that will come out in summation. The whole text messages being ghosted, and right before he gets agitated with John in the bar, allegedly, he witnesses that. So that was helpful. Then they brilliantly do what we used to colloquially call like a double direct as a prosecutor. If you can get more out each time and remind the jury of favorable evidence, they do it. So they take a witness who there's no evidence that she even saw in real time in her own eyes this exchange between Higgins and John O'Keefe. And what do? They play the video and they have her narrate it, and they have Chris Albert holding Higgins back and all. I mean, so that, that's another benefit that they get. Then I guess perhaps very importantly, they get her to say, look, clearly she is the responsible one of this cast of characters. Okay. I'm a pharmacist. I'm not a party woman. I don't even want to go out. I mean, I know when it's time to go home. Thank God for her sake. They went home. So she's the responsible one. And she says, you know what? The majority of the time I was sitting there with Karen, she looked fine to me. Okay. Yeah. She was drinking something that I assume was alcohol. She's not slurring her words. She's not, she's not visibly intoxicated. She did a nice job in establishing that Karen was at least in control of her faculties, not out of control, which dovetails nicely with what Nagel and Maxson said a few weeks ago when they were driving, turning on to Fairview. She was driving normally in their estimation. And then they finish with, how compelling is this? I don't know. But if you're going with something happened in the house that might have involved Higgins and Brian Albert, and in your theory, Jennifer McCabe did some weird things after the fact. They finish with her saying that, I thought it was weird when McCabe went up to Karen and said, you're coming with us. Mm-hmm. Is that the most impactful thing in the world? No. But do I think it was effective as a whole? Yeah, I think they sympathized Karen. They made it appear from a responsible witness that she may not have been as intoxicated or out of control as the prosecution wants to allege. to some extent, she's negating this theory that they hate each other. They're fighting all the time. She draws attention to the Higgins-John dispute. So, yeah, I mean, it was a nice way to end the day for them. Not a home run,
And
but
every
nice.
trial, I call witnesses that make the jury have a certain kind of feeling, right? It's like, I get the case about facts, not feelings, and what it's like, fine, but every single witness can't have all these details that the jury's got to remember and write down. It's like some of them just got to be like, oh, maybe I like that person. It's like there's been so much that has tried to make it be like I don't like Karen Reed. That anything you can do to help that, I think, is important. And I think she did a great job with that.
She did, because, I mean, if you look at the trial up to now, and probably you could go to the end, because I don't know that there'll be that many more of these types of people. If you said in this entire trial, who is the single most likable witness, personality, demeanor, just like fun, but responsible, nice, she wins it going away. I mean, even the way
basically confirms that.
I mean, she's telling the story. I didn't even want to go out, and I kind of got schnookered by my husband. I mean, she's likable. She's relatable. And the most likable and relatable witness in this case has left the jury with the impression, I like Karen. And I know Jen McCabe. That's important. I know all these people. I like Karen. That's effective.
I agree. And Karen Reed said after court that they're going to be done on Tuesday, so 3 days left. We know there's ARCA. ARCA's probably going to be over a day. So a couple other witnesses, but I mean, they're almost done. So at this point, I mean, there was doubt in the Commonwealth's case. They've highlighted it. They've basically, from my opinion, given us a better alternative with the dog bite, dog scratches, but confirmed that this did not happen from a car accident. And we haven't even heard from ARCA yet. So what are your thoughts as far as like what's left, and what are you looking forward to on the defense side besides ARCA? Who do you think they're going to call?
Well, I mean, again, especially given the timeline we're talking about, Tuesday is basically 3 court days from now. It's not a lot of court time.
Right.
That tells you, once again, you're not seeing Higgins. You're not seeing anybody named Albert. You're not seeing these people. They're not doing it. We know there's going to be 2 ARCA witnesses. We know that cross-examination is probably going to be 2 hours too long about small payments and signal messages and all that stuff that, frankly, is just not at all impressive. But whatever. I would imagine they're going to call their medical examiner. That's somebody I would definitely call that can buttress Bederow, another MD on their side, who I think was also previewed that they will say hypothermia was not a contributing cause of death. I mean, that could be important. That could support their claim he wasn't out there all that time. Right. So I think, that is something that they'll definitely do. Other than that, I'm not sure who else other than, I think, will they call Wing, the other dog person? Yeah. They may as well. I mean, I don't know why you wouldn't. I mean, if you've already got strong evidence from Dr. Russell, but if you can pile that on with a non-medical person,
knowing that it's coming in rebuttal.
Yeah. So I would do it. I would empty that tank. Other than that, they have Green, the cell phone guy. I think that they should do that. Again, as far as the Google search goes with Jennifer McCabe.
I thought he was medium trial 1, personally.
He wasn't great. No, his demeanor. I don't know if it's so much his science as much as he needs to be firmer. And, maybe that's an issue. But my point is, the Google search is house money for the defense. Mm-hmm. I mean, if the jury doesn't conclude that Jennifer McCabe didn't do it at 227, defense doesn't lose. On the other hand, if the prosecution doesn't disprove it happened at 227, they're cooked. Because if the jury thinks that's possible, there's no reason for that search. So Green, if he can just add some confusion, dispute, debate on that issue is helpful. But I think there's other points where he's really important. And again, it goes to completing the impeachment of Jennifer McCabe. Okay? If he's able to say, separate and apart from the Google search, that she made, I think the number was 4,500 Google searches and deleted 1. And it happens to that one. That alone, you're calling her. Okay? Calling him. If you have evidence that she deleted whether she claims that they're not manual, every single phone communication she made up until around 9 o'clock when Lank came back, you're doing it. And then I think there's something else that's really interesting. And I think you have to factor in the way jurors think and being a younger crowd. They know what Google is. They know how this works. Jennifer McCabe has testified in a way to make it appear that after this happened, that she was distraught to the exclusion of every other emotion, that, you know, this and whatever. I mean, it was her friend. I don't mean to minimize that, but that's not what the text messages with her family show. The family messages show an intent to get ahead of this and stay one step of the police. What do they know? Who's telling what? That's different than feeling distraught. And there's one other thing that I would add to that, which I think a younger jury will also appreciate, which is she's Googling herself in the aftermath of this terrible loss of her friend. And you would only Google yourself for one reason. Is the public gonna, like, am I part of this? Who thinks like that when you're mourning your friend and you know, who died on the front lawn of your brother-in-law's house and through no fault of your own? Why are you Googling yourself? That's weird.
Been used in multiple trials against criminal defendants.
That is weird. I don't really follow that Idaho case a lot. I'm like the true crime guy. This case I found particularly interesting, but I am aware in that case that they're making a big deal out of that. Why would this guy be so interested? And for her to Google herself, given, you know, her apparent emotions that she's projecting, is really bizarre. So I would call green for all those reasons. Other than that, unless I'm missing something, I think they're pretty much done.
I'm sure we're missing something that somebody's going to remind us of in the chat. There are multiple witnesses, but I am really interested to see how they finish up, what their strategy is, how they close all these loops. And then I do think rebuttal is going to be a couple days. I don't think it's going to be a 1 hour, one witness rebuttal. I think he's going to have a couple people to call, and maybe even some new stuff like with the dog bite expert that they have. So the case is not going to be over Tuesday, but we're definitely getting close to the end of this trial, and it's going to be in the jury's hands soon. And God only knows what will happen from there. So thanks for joining me, Mark. We'll get together again at some point if schedules allow, but I always love hanging out with you, talking to you about this stuff. Really appreciate your take. So thanks for being here. Till next time, we're out of here.
Yep. We'll talk soon. Bye.
Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.